from the regulatory guide of from the reference guide to regulatory compliance. I'm reading from the deposits section 3, collection of checks and other items through Federal Reserve banks and fund transfers through FedWire. Regulation J governs the collection of checks and other cash and non-cash items and the handling of return checks by Federal Reserve banks. It also covers the rules governing funds transfers sent through FedWire. Its purpose is to provide rules for collecting and returning items and settling balances. Check collection coverage. A. Senders, which includes 1. Depository institutions, including A. Banks, B. Savings and loan associations, and C. Insured credit unions. 2. Senders include clearing institutions, which is a corporation or a non-depository institution that maintains an account with a reserve bank. 3. Senders include another reserve bank. 4. An international organization for which a reserve bank is empowered to act as a depository agent and maintains an account. 5. A sender includes any of the following foreign correspondence for which the Federal Reserve maintains an account. That's A, a foreign bank, B, a foreign banker, C, a foreign state, or D, a foreign correspondent or agency. Lastly, a branch or agency of a foreign bank that maintains reserves under the International Banking Act of 1978. Items covered under Reg J. An item is an instrument or promise or order to pay money, whether negotiable or non-negotiable, sent by a sender and payable in a Federal Reserve district or sent to and collectible in funds acceptable to a reserve bank. An electronic image of an item together with electronic information describing that item in an approved format will be considered a valid instrument. Common forms of instruments are the following: checks, which are drafts drawn on a bank and payable on demand; substitute checks, bank drafts, which are checks drawn by one bank on another bank; cash items, which are checks or other items payable on demand and collectible at par and accepted at the reserve bank; and non-cash items, which are items that a reserve bank classifies as requiring special handling. Subsection 2, check collection requirements. Reserve banks must issue operating circulars which, together with Reg J, govern the details of handling items through the reserve bank, including handling of government items and foreign instruments. B. Sending items to reserve banks. A sender other than a reserve bank may send any item to the reserve bank regardless of whether the item is payable within that reserve bank's district, unless the sender's administrative reserve bank directs it to send the item to a specific reserve bank. Reserve banks may permit or require a sender to send direct to another reserve bank any item payable within the sender's reserve bank's district. The following parties are deemed to have handled items in this order. This order determines the relationships, rights, and responsibilities of the parties under Regulation J, Regulation CC, and the Uniform Commercial Code. That's A, the initial sender; B, the initial sender's administrative reserve bank, which is determined to have received the item from the initial sender; and C, the reserve bank that receives the item from the initial sender if different from the sender's administrative reserve bank. And lastly, any other reserve bank that receives the item from a reserve bank. Reserve banks must receive cash items and other items, checks, at par. And senders' agreements. By sending an item to a reserve bank, a sender authorizes the reserve bank to handle the item based on this regulation and the reserve bank circulars. Warrants. The sender also agrees or warrants to each reserve bank handling the item that it has good title, that it is entitled to enforce the item, and that the item has not been materially altered, and that the item bears all endorsements applied by parties that previously handled the item in paper or electronic form. Sender warranties for electronic items. The sender makes all of the warranties set forth in the Uniform Commercial Code as if the item were subject to the UCC, and makes all of the Reg CC warranties as if the electronic item were a paper item subject to that regulation. Sender warranties for electronic items that are not substitute checks. For instance, if the electronic item is not a representation of a substitute check, the sender represents that the electronic image of the item accurately represents all of the information on the front and back of the original check at the time of the truncation of the item. The information contains a record of all magnetic ink character recognition microline information required for a substitute check. The item conforms to the technical standards set forth in any operating circular. No person will receive a transfer, presentment, or return of, or otherwise be charged for an electronic item or the original item such that a person will be asked to make payment on an item that he or she has already paid. The sender's liability to reserve banks involves the sender agreeing to indemnify each reserve bank for any loss or expense resulting from sender's lack of authority, any action taken by the reserve bank within the scope of its authority in the handling of the item, and any warranty made by the reserve bank under Regulation J, Reg CC, or the UCC. The sender's liability for warranties and indemnities that a reserve bank makes for a substitute check is subject to the following conditions and limitations. 1. The sender of an original check is not liable for amounts paid by the reserve bank, absent the sender's agreement to the contrary. 2. The sender's liability under Regulation CC is not altered by these Reg J provisions. And 3. A sender of an electronic item that is not a substitute check is not liable for any amount paid by a reserve bank that is attributable to the reserve bank's own lack of good faith or failure to exercise ordinary care. The sender's liability under other law is basically not preempt. So nothing in this regulation limits any of the sender's liability that arises under state or federal law or regulation or any agreement with a reserve bank. Recovery by reserve banks. Section C. The reserve bank may recover from the sender the attorney's fees if a action is brought against the reserve bank on the basis of failure of sender to have authority to make the required warranties and agreements, any action by the reserve bank within the scope of its authority in handling the item, and any warranty made by the reserve bank. The reserve bank may recover by charging any account on its books maintained by the sender if the reserve bank makes written demand to sender to assume defense of the proceeding and the sender has not made any other payment arrangement acceptable to the reserve bank. When sending an item to a reserve bank, a sender may and any prior collecting bank grant a security interest to the sender's administrative reserve bank in all of their respective assets in the possession of the reserve bank to secure any of their obligations to the reserve bank. This security interest attaches when any warranty is breached or any obligation to the reserve bank is incurred. The reserve bank may take any action under applicable law to enforce its security interests, including exercising its right to set off amounts against any funds it holds. Section D, liability of reserve banks. The reserve bank is an agent or a sub-agent of the owner of the item. Agency terminates when the reserve bank receives payment for any item in finally collected funds and makes the proceeds available to the sender, and the time for commencing all actions against the reserve bank has expired. Limitations on reserve bank liability. A reserve bank will not have any liability for an item except for the reserve bank's own lack of good faith or failure to exercise ordinary care, or for the liability as provided in Reg CC. The Reserve Bank may rely on the routing number or other designation of a paying bank or non-bank payer, and the Reserve Bank is not responsible for delays resulting from any designation on check, whether inscribed by magnetic ink or other means. Warranties of Reserve Banks. By presentation or transmission of an item, a Reserve Bank warrants to subsequent collecting bank and paying bank that the Reserve Bank has good title to the item has not been altered, and the item bears all endorsements applied by parties that have previously handled the item in paper or electronic form. Warranties for electronic items. The Reserve Bank makes all warranties for electronic items as though they were checks. Warranties for electronic items that are not representation of substitute checks. The electronic image accurately represents all the information on the front and back of the check at the time it was truncated. The information portion of the item contains a record of all micro information required for a substitute check under Reg CC. The item conforms to the standards for an electronic item set forth in operating circulars, and no person will receive a transfer, presentment, or return or be charged for the electronic item, the original item, or a paper item, such that the person will be asked to make payment on an item that has already been paid. Indemnities for electronic items that are not representations of substitute checks. This includes when the Reserve Bank agrees to indemnify the bank to which it transfers or presents the electronic item for any losses that the recipient bank incurs under Reg CC for a substitute check it later creates, except for losses attributable to the recipient bank's lack of good faith or failure to exercise ordinary care. Time to bring action against a Reserve Bank. Claims against Reserve Banks for failure to act in good faith or exercise ordinary care must be brought within 2 years, and claims against Reserve Banks for warranties given on electronic items that are not substitute checks must be brought within 1 year. Presenting items for payment. A Reserve Bank or a subsequent collecting bank may present an item for payment or send the item for presentment and payment. The Reserve Bank may send an item to a collecting bank with authority to present it for payment or send it for presentment and payment. Third, the Reserve Bank may present an item for payment at the place requested by the paying bank, at a place requested by the non-bank payer, through a clearinghouse, or under a special collection agreement. Fourth, within a Reserve Bank's district, the Reserve Bank may present the item directly to the paying bank or a non-bank payer as applicable. Or, lastly, outside a Reserve Bank's district, the item is usually sent to the Reserve Bank of the other district, but may, with agreement of the other Reserve Bank, be sent directly to the paying bank or the non-bank payer. G. Presenting non-cash items for payment. A Reserve Bank may present a non-cash item for payment if instructed to do so by the sender, and if the item provides that it must be presented for acceptance, or whether the item is payable elsewhere than at the residence or business of the payer, or the date of payment of the item depends on presentment for acceptance. Reserve banks cannot assume any other obligation to present or send non-cash items. Any documents accompanying a non-cash item must be held unless the sender authorizes delivery. Section 8 is payment. The general rule is a paying bank must settle for an item with its administrative bank, whether or not it received the item from the bank. Settlement with its administrative bank is deemed to be settlement with the Reserve Bank that has sent the item. Cash items. A paying bank must pay for a cash item received from a Reserve Bank by the close of Fedwire for the day on which it receives the item, unless it returns the item before then, or it pays for the item by debiting an account on the Reserve Bank's books, paying cash or other method approved by the Reserve Bank. Proceeds must be available to the Reserve Bank by the latest of the next clock hour, that is, after the hour the paying bank receives the item, 9:30 Eastern Standard Time, such other time as provided by the Reserve Bank's operating circulars. If a paying bank does not meet these deadlines, it will be subject to overdraft charges. If the bank is closed on a reserve bank banking day and therefore does not pay the item by the end of the day, the bank must pay the reserve bank float compensation.